Okay, so hi everyone. Welcome to our chat with Matt Margolis. He's our local estate planning and elder law attorney. He has been with the Y apparently now for about 8 years, giving these wonderful chats. This is more of a question and answer format. It's going to take about an hour. This is obviously presented by the North Suburban YMCA. It's part of our Y.E.S series, which are free and open to the public. Um, and yeah, with that, Matt, I'll let you take it away,
Sure.
and this should be interesting.
Yeah. All right. Well, thank you so much. I am happy to be here. Yeah, I have been doing these talks now for 8 years, as Amy said. I can't believe it. It seems like it's been like three or four, but I'm happy to do these talks. So I've got an estate planning and elder law practice in downtown Park Ridge, even though I'm a Northbrook resident. So, I'm around town depending on where you guys all live. I've been doing I've been focusing just on estate planning and elder law as well since 2011. So a little over 13 years. It is all I do. I don't do traffic violations. I don't care how simple they are. I don't do divorce work, personal injury. I don't even, deal with like a real estate, what somebody would call a simple real estate closing. This is all I do. Um, so really typically we've got, I've got an agenda and there's things that I'm talking about and, I go sort of down different paths and some of the talks I give have some overlap because there's just certain things that kind of creep over um, from topic to topic. But today is really for all of you to ask me questions, right? So today is the estate planning and elder law Q&A. I don't have an agenda. I can definitely, I'm happy to answer any and all questions that people have. So this is your opportunity to ask me questions and not get a bill for it. Never, my clients would never get a surprise bill anyway. But I'm here to answer any questions you have. I mean, they can be as personal as you want them to be, and as comfortable as you are asking them in front of other people. Um, and if anybody doesn't necessarily have a particular question, then I'm happy to maybe discuss a couple things that I think are important. Um, but I really am not going to go down any paths in extreme detail. There might just be a couple things that I might touch on, that we're kind of looking at, sort of like year end that sort of impact us on the estate planning side, but really I think are just good things for people to consider in general. So I mean, without further ado, I'm an open book. Ask me any questions you want, other than how much I weigh.
There, I have a question,
Okay.
Gloria. Um, yeah, my question is, in determining what trusts to do, is it better for a couple to have two individual trusts, or is it better to do a joint trust? What are the pros and cons of each? And, what would be the reasoning behind what might make a couple determined to go one way or the other?
Yeah. Well, Gloria, that's a great question. It's something we discuss really often with our majority of estate planning clients that we sit down with for the first time. So I think a lot of people would benefit from this. So the biggest difference between using a joint trust, okay, for a married couple versus two trusts, typically will fall in a situation, or the reason for two trusts versus joint trust, for us at least, will typically be a situation where a married couple has a taxable estate. A taxable estate in Illinois is over $4 million.
Mhm.
Okay, so in Illinois, we each have a $4 million estate tax exemption. Okay. Um, I'm not hearing anything on the horizon that's changing anytime soon. And so what that means is that at my passing, I can pass on $4 million tax free, right, to my beneficiaries, right? The total of my IRAs, 401ks, brokerage accounts, real estate, etc. Okay, I can pass on up to $4 million tax free. And my wife, okay, so if we're married, Your spouse also has a $4 million coupon, we'll call it. Okay. So let's refer to it as a coupon, kind of a fun way to think about it. So my wife also has a $4 million estate tax coupon. All right. So technically we could each pass on $4 million for a total of about $8 million. Now, here's the thing. Even though at my death, I can pass on an unlimited amount of assets, or I can transfer an unlimited amount of assets to my wife, tax-free. Okay, so with spouses, that $4 million limit doesn't really impact you when doesn't impact us when the first spouse dies if we're leaving everything to our spouse, because Illinois is not going to tax that, right? So let's say my wife and I just have a $6 million estate. We definitely don't. I wish we did. Let's just say we did, right? Say we had a $6 million estate, and at my death, all the assets are now in her name only, right? And we'll use the example that we have a joint trust. Okay, we have the Margolis trust, and there's $6 million in there. No issues when I die. Okay, there's no taxes due. However, when my wife dies, and that $6 million gets passed on to our kids, because that's what our estate plan says, when it gets passed on to our kids, $4 million will pass tax-free, $2 million will be taxed. Okay. As far as what the taxes are, it's based on a bunch of factors, because in some cases, if you gave away certain amounts of money during your lifetime, it can kind of offset some of the taxes when you die, but not completely. So in general, I tell clients, look at that tax rate. Figure it's going to be somewhere between 10 and 20%. Okay, that's like a really, really safe range to use. I know it's a big range, but just think of it that way, right? And so if we have $6 million and we use a joint trust, we could be subject to anywhere from $200,000 to $400,000 of estate taxes, right? Based on that 10 to 20% on $2 million over the limit. You're not paying taxes on that $4 million. Okay, you're only paying taxes on what's over the 4. So the reason why we would do 2 trusts in this example of having a $6 million estate is that we would try to even out. We would try to sort of divide and even out our estate between the 2 of us. Okay, and what I mean by that is that my wife would have her trust and I would have my trust. And as best as we could, we would try to have about $3 million in each trust. Now, it's never going to work out that way, because some clients have, IRAs, and that completely offsets things. And you cannot put an IRA in a trust. The IRAs stay in our names. We just make sure that we've got beneficiaries listed. But let's just make it really simple to understand. And let's just say that there's no IRAs involved. We've got $3 million of assets in each trust. Okay. House, brokerage accounts, checking, savings, etc. At my death, my trust, the $3 million in my trust, does not go to my wife. It stays in my trust, and my trust gets a taxpayer ID number. Okay. It gets a taxpayer ID, employer identification number, called an EIN. Whatever you want to call it, it's the same thing. My trust basically, becomes its own entity. Now, my wife, in most cases, would be the trustee, and she's also the beneficiary. So she still has access to the assets in my trust, and she can still use them for her benefit. And then my trust is going to file its own tax return every year. However, the assets in my trust never get added to my wife's estate, thus bumping her over the $3 million that she already has in her name, in her trust. So at her passing, the $3 million or so that's in her trust goes to our kids. The $3 million or whatever's left from my trust goes to the kids, and it passes tax-free. Mm. So that would be the most common situation where we are going to use 2 trusts, is when we have a married couple and their estate is over $4 million. There are some attorneys that will only do separate trusts. There are colleagues of mine, attorneys that do what we do kind of fall into 2 camps. There are some attorneys that will use a joint trust when you really can use it, right? I mean, if we're meeting with clients and they've got $1 million of assets total, value of their house, brokerage accounts, IRAs, etc., total it all up, it's $1 million, even if it's 2, even if it's 3. We're likely doing a joint trust. Now, it's different if it's a $3 million estate and the couple is like 35 or 40 years old, right? We know that they're probably going to get bigger than that, and we'll probably do 2 trusts. But, for couples that we work with, and again, I don't make the decision for my clients. I'm here to educate them like I'm educating you guys. And then people I like my clients to make their own decisions. Of course, I will chime in and provide advice or guidance or a recommendation if they ask. Of course, that's what I'm here for. But I really like clients to, our goal is to give them an understanding like I'm trying to do right now so that they can understand and say, okay, well, this is what our situation looks like. And I understand the one or two trusts. And I think that this would make the most sense. And of course, I'll say, yes or no, whether I agree, maybe we'll discuss some things. But I went on a little bit of a tangent there. There are some attorneys out there that will only do two trusts. Doesn't matter if the couple has an estate that's worth $400,000. They'll never do a joint trust. And I just don't believe in that. I think that there's times when a joint trust makes sense. If it's all we need, then my goal is to try to keep planning more simple, try to make it easier on people. There's no reason to set up two trusts. So the most common situation for two trusts, Gloria, would be where an estate's over 4 million. But then there's other situations where married couples will do two trusts. It's really because maybe it's a second or third marriage, and the couple always has maintained their assets separately. And their idea is, okay, well, when I die, I might want to provide something for my wife, but at the end of the day, when she passes away, I still want whatever's left from me to go to my kids, and she wants whatever's left to go to her kids. Right. And so there's sort of the other situation where you've got, a blended family, and there might be good reason to have two trusts in those situations too, right? Because those, unless it's maybe a second marriage that's lasted for 35 or 40 years, right? That might be a little bit different, right? I'm not, none of these are absolutes, right? Everybody's different. Everybody has their own idea of how they want to plan. But that might be another situation where we would use two trusts sort of to make sure that a couple's estate kind of went to their children and not all to their second spouse. Because think about it this way, right? What if it's a second or third marriage for me, and my wife and I now have kids from prior marriages, and we have separate plans. And my plan says that everything goes to my kids when I die, and her plan says everything goes to her kids when I die. I mean, if I died, let's say my plan left everything to her first, and I died first. Well, then the reality is then at her death, everything would just go to her kids, and my kids would get nothing, right? So these are just things that we like to talk through and make sure that we're accounting for and ensuring that we're planning correctly and honoring people's wishes. So I might have given you more than you asked for there, but.
So if neither of those situations apply, so is it just easier to do a joint trust versus two?
Definitely. In my opinion, yes. Yep. Because if we have separate trusts and we don't really need them, the issue then becomes, at my death, my trust gets a separate taxpayer ID number and the money is now in that trust and my spouse can still access it, but now we're filing a separate tax return really for nothing.
The mechanics of moving.
Right. So we're kind of putting ourselves through more of an administrative, more of an administrative hassle at the death of the first spouse if we have two trusts and we really don't need them. So yeah, I would definitely say that if there's not a taxable estate, so if the estate is not over 4 million and it is, other than winning the lottery, it's unlikely that we're going to be over 4 million, and it's not a second marriage, and it's a couple that keeps all their assets owned jointly, a joint trust would be something that I'd be recommending. I'd probably say 99% of the time. I can't, that would be very likely.
What about the mechanics of with one trust? If let's say you have a bank account and you want to go to another bank, and one of the spouses is out of the country, can you set it up so that only each one signature is required rather than two to do things?
Yeah, so typically another really good question. I can't see you, so I'll call you Mr. Gloria.
Okay.
But yes. So in every case, and this isn't really a joint trust question, so I just want to make sure everybody's aware. So this would be like whether we have joint trusts, whether we have separate trusts. Because even if we have separate trusts for a married couple, the people that have access to the money or the assets that are in the trust, right? Because when we create a trust, obviously I didn't give any background on trust today. I've done that in plenty of other talks, and I'm not necessarily going to do that right now. But when we have a trust in place, the person that has access to all of the assets in the trust, bank accounts or brokerage accounts or real estate, that person's called the trustee. With a joint trust with a married couple, typically both spouses would be trustees. They'd be co-trustees. You know, even if we have separate trusts. So even if my wife my wife has her trust and I have my trust, we're still going to be co-trustees of each trust, because just because we're dividing the assets up, we still both want to have access to all the assets. Okay. So to answer your question, I can only tell you how we do it. I mean, in our office, at least with my clients, anytime we have co-trustees, I am always going to draft it in a way where the trustees can act independently. You know, there's some clients that say, well, I want both my trustees to have to sign off on things. And then typically, we'll talk through that, because from a logistical standpoint, that can be a real pain and that can be really difficult. And so in those cases, I might recommend that we just do, naming one trust at a time versus two trust, or one trustee at a time versus two trustees together. But if there's two trustees acting as co-trustees, then yes, typically we will have language that says they can act independently. Now, as far as opening a new account, though, that's different. Okay, if you're going to a bank and you want to open a new account, or anything that has to do with real estate, the signatures of all trustees will be required. Okay, but that's as far as opening new accounts are concerned. Once an account is open, and there's a checking and savings account at Bank of America in the name of the Margolis Trust, and my wife and I are co-trustees. Once that account is open, either one of us as a trustee can access the account, pay bills, write checks, do whatever we need to. I would look at it very much like how a joint account operates. That's not even in a trust, right? Just a joint account that you would have with your spouse.
Okay.
Does that help? Does that answer your question?
Yeah, yes.
I have a question. So I am power of attorney for a friend of mine who is the beneficiary of a trust. And so she had some cognitive disabilities as a result of an illness, but she's all with it.
Okay.
But her father decided to make her two brothers to be executors of the trust, successor. One is the original, one was the successor. The older brother, when he managed the trust, everything was fine. He died. The younger brother has treated her terribly. She is currently living in a nursing home where she gets to keep $30 a month of her Social Security when there are two completely paid for houses that are in the trust. And one in Chicago, one in Fort Myers, Florida. Plus there's other assets in the trust, but he refuses to give her a copy of the trust. So she has no idea exactly what's in it. And like a CD that matured in the trust, he had to give it to her. Well, then a lawyer told him, don't give it to her, because then, Social Security or somebody's going to see it and, want to know why she has this money. So then he went and used it to pay for her funeral expenses, so that the check was made out to her, but then all the money went to the funeral homes. And so he's told her that he does not have to give her a copy of that trust. And the bank has said that they don't have to give her a copy of the trust. And I can't understand, if you are a beneficiary of a trust, how the bank can say, I don't have to give you a copy of this.
Right. So the bank, it's actually not the bank's. So this is a little bit of I'm not gonna say complicated one. I feel bad for your friend.
Yeah.
So did you say she's in a nursing home?
She's in a nursing home as a result of, he would abuse her. He would emotionally abuse her. He would psychologically abuse her. He even physically intimidated her.
Oh,
And
geez.
she actually ended up in the hospital because he would get her so upset, her blood pressure went through the roof. But he actually called the police because he wanted to have her committed. And the police realized what was going on. And so they sent her to the hospital instead. And then from the hospital, she was discharged to the nursing home. And so that's where she lives. He does not, and again, I'm not saying this to sound like I'm a great person or whatever, but my family and other friends of her family buy her clothes, buy her shoes. He locked her teeth in the house. He changed the locks on the house that she was living in. And all of her clothes, her teeth, all of her identification was all locked in that house, and he refused to allow anybody to go in it to get it for her. And so he has her so upset and intimidated that she she goes between,
Yeah.
I want to get my stuff and I just want him to not be
right.
able to hurt me.
Yep.
So that's why I'm her power of attorney, to try to help her,
Yeah.
And so I don't know how to proceed. She doesn't have a lot of money. I mean, actually we used, for my aunt, we used your other partner, Weldon.
Oh.
We used her, she helped my aunt out because my aunt was in a similar situation with her children, which is
Mhm.
why I trust you guys.
Yeah, thank you.
But I don't, she's in the south suburbs. You guys are out in the northwest suburbs, so I don't know if
Yeah.
you do things out that way. But I just
Well,
want to
here,
try to help her.
yeah. Okay. Well, again, I'm really sorry to hear about what your friend's dealing with. So the bank would not be so in these situations, the financial institution really isn't the appropriate, wouldn't be the appropriate party to pass along a copy of the trust. It's the trustee, and the trustee is,
Refusing.
again, it would depend. It depends on the language of the trust. I mean, without reviewing it, I don't want to jump to any conclusions. But if somebody is in fact a beneficiary of a trust,
Mhm.
they are entitled to see, if not the entire trust, at least they are entitled to see a portion or the portions of the trust that show what their beneficial interest is. And then that person is, and this is, I would imagine, is this a situation where you said this was a trust created by your friend's dad,
Parent.
and he's deceased, and they are
Yeah.
deceased, parents are deceased. Yeah.
It was a joint one from her parents.
Okay.
They had separate ones and then he put them together, and so, and
Yeah.
the other thing is that the father and all these other family members will tell you that her father said repeatedly, Patty, you don't have to worry about money. There's enough money in here to take care of you, and you can live in that house until you die if you choose. So his stated purpose for this was primarily for her benefit. So I haven't read it, so I don't know if she's the primary beneficiary and then the other family members are. But yeah, he's just not very kind to his sister.
What I mean, the short answer, without, because there's not a whole, not can't go too deep into this.
Yeah.
Just because while we do, you worked with my partner Lauren, while we do help on the Medicaid side as far as situations that get a little murky like this, could be litigious. We really don't handle those. However, I would say if you want to shoot me an email, I can connect you with a colleague of mine that would likely be able to help. I know you said south suburbs. My colleague is closer to us in proximity. But if you send me a separate email, I'd be happy to see if we can connect you with somebody that you could talk to. But
you.
yeah, I mean, generally, the long story short, if somebody is, and this applies to everybody, I mean, if somebody is a beneficiary of a trust, you are entitled to a few things. Okay, you are entitled to, and you can waive your right to it. All right, so I can say you don't need to do this if I'm not going to ask you for it, but you are entitled if you want to see it. You're entitled to at least the portions of a trust that show your what you're entitled to, right? To show your beneficial interest, and then you are also entitled to an annual accounting. And an accounting would be, think about like a spreadsheet, which shows, at the start of 2024, there was $1 million in total in all these various bank accounts that were in the name of this trust, right? And you would have each bank account listed. You wouldn't just put $1 million. You'd have every bank account listed and show how much is in there. And then you would show, over the course of the year, all the expenses that went out, right? So it started at $1 million, and even though over time there's maybe interest being earned on some of the accounts, there was expenses to the tune of $84,000. And at the end of the year, the account is still close to $1 million, because even though you spent 84, the money is still invested and it's earning some interest, and now we're close to $1 million. But so again, you're not just entitled to the portions of the trust that show your interest as a beneficiary, but you're also entitled to be asking for an accounting. And if you're not getting those things, then the trustee, there can be some serious consequences. I mean, the trustee has a fiduciary duty to provide that information. And if a trustee is ultimately not, acting in a beneficiary's best interest, that's a problem. So there's definitely some problems here. And something should be done.
That's exactly what I said, is he has a fiduciary interest, duty to her. Now,
Yes.
are you also entitled to the annual tax return filed for the trust? A copy of that?
You
Is that part of this annual accounting?
could, I don't see any problem asking for it. I mean, I can't see a trustee if they're providing an accounting that's on the up and up. I don't see why they would not be willing to turn over a tax return.
Okay, I
I
thank
wouldn't
you
see an issue
because
with that.
I've been trying to find a lawyer, the right lawyer, because I have a little bit of money to give, like as a initial office visit or whatever, somebody from my church. People who don't even know her are donating money to try to help her, and her
Yeah,
own brother
so
won't.
nice.
Yeah,
Yeah.
so, okay, I will do that. Thank you.
Yeah, of course. I'm sorry. Again, I'm
Do
sorry
you
to hear
have
about your
your
friend.
email address in the chat? Oh, there it is.
Uh,
Thank you.
oh,
Yeah, I
thank you,
just
Amy.
put it in there for you.
Thanks, Amy.
Thank you so much.
Mhm.
Well, I have another question if somebody else doesn't want to ask something.
Go ahead, Gloria.
Okay, so if one spouse has to go on Medicaid, what are the obligations of the other spouse to enable that to happen in terms of, income, assets?
So it's a really good question. And actually, these numbers have changed quite a bit in the last couple of years. Okay, so it used to actually be a lot different than it is right now. So if I go into a nursing home and my wife is at home, all right. So some of these numbers just went up. So I didn't catch the name of the woman that was just speaking, but she mentioned that her friend is entitled to only $30 a month. That number actually has just gone up recently, so it actually should be $60 a month that you're able to keep from your income. So what that means is, let me go back a second. If I'm in the nursing home, if I'm the one that's in the nursing home applying for Medicaid, I get to keep $60 a month of my income. Okay, so if I get $2,000 from Social Security, I get to keep 60 bucks. If I have a Medicare supplement, I can keep that Medicare supplement and I can pay for that Medicare supplement also. And then whatever's left after I keep the $60, I pay for the Medicare supplement. The remainder goes to the nursing home. All right. So first I'm going to kind of give it to you how it works for a single person, and then I'll add the spouse. Okay. It's just kind of easier to go in that direction. So that's how it works from an income standpoint. As far as assets are concerned, right? What can I keep? What money can I have in the bank? How does this work with if I have a car or a house? So as far as my assets, I can have $17,500 in my name. Okay, this number actually just went up pretty significantly. It was $2,000 for a very long time, up until about 18 months ago. So it's a huge change that it just went up to 17,500. Okay, so I can have $17,500 in my name. I cannot own a house. Now there are aspects of the Medicaid policy that say that technically a single person can own a house if there is evidence that they have a not just an intent to return home, but that it's likely that they could return home. We've been doing Medicaid work for 13 years now, and I don't think we've ever been able to keep a house for a single person, because once you're dealing with somebody that's in a nursing home, we know in most situations when somebody's in a nursing home just for rehab or for more of a temporary period versus when somebody's going to be in there long term. And so, we've never really been able to make the argument that this person's likely going home. So I would say for a single person, really, you could look at the idea that you are allowed to have $17,500 in your name, no real estate, no car. Okay. Now, if you're married, okay, so some of these numbers have just changed recently as well. So my spouse can have, at least for this year, and the numbers are going to go up a little bit over the next couple of years, but for this year, my spouse can have $129,000. It's 129,84 to be exact, 129,084. But to make it easy, $129,000. Okay, so my wife can have $129,000. She can have a house with, and this is a change that's happened recently. There used to not be an equity limit of how much equity you could have in a home, but she can have a house with equity of up to $713,000, which is pretty, pretty nice, good size house. And then as far as her income is concerned, okay, so her income can be at a certain point. Her income can be $3,853.50 a month. Okay, so 38.53, just to be for a rough number.
Can
Okay,
she own a
that's what her
car?
monthly, and she can own a car. Sorry,
Yeah,
so she can have a sorry,
okay,
so she
so
can have a
if
car.
the income of the spouse is more than $3,853 a month, then she's obligated to give anything that's over that amount to the nursing home, or?
No, no. So let me explain that. Let's explain how that works, and because that's a really good question. I was going to go there next. So first, let's talk about situations where, because I would say in majority of situations that when we're doing anything Medicaid related, the income from the spouse tends to be less than the 38.53. Okay, I'm obviously not saying in every case, right? Some people have really nice pensions. Okay, so I get that. But let's just use the example that in most cases that spouse's income is less than 38.53 a month. Let's say it's 2,000. Okay, so let's say my wife's income is 2,000 a month and my income is 2,000 a month. Okay, if I was a single person, I would get to keep the $60, pay for my Medicare supplement, and then the remainder of my income would go to the nursing home. When I'm married, though, if my wife's income is not up to that 38.53, I can then transfer the income that I would have otherwise had to have given the nursing home each month because it was more than I was allowed to keep. And I can transfer that to my spouse to get her up to the 38.53. Okay, so first I just wanted to go through that in some cases, there might be I might be able to transfer income from me as the Medicaid recipient to my spouse who's at home to get her up to the 38.53. Okay, and that can be really beneficial for some people. But then, like you said, Gloria, there are some cases where, what if it doesn't matter what my income is at this point, right? Whether my income's $1,000 or $1,500, let's just say my wife gets a pension and it's $6,000 a month, so it's over the 38.53. Technically, what the state can do, there's like this table that they use, and I don't know. I'm going to kind of give you what I believe it says. It's like she has to contribute, or the state can potentially ask her to contribute. Hold on, let me go back. The state has the ability to ask her to contribute. I think it's like $5. And I know this is a difference, but I'm not looking at the table right now, and it almost never comes up, to be honest with you. But it's like she has to contribute $5 for every $100 that she's over the 38.53, or it's $5 for every 500. And I know that's a big difference because that could be, difference of $25 per 500, but it is a smaller amount. Okay, it's a smaller amount, and I will say that even though the state has the ability to seek it, vast majority of times, they don't. So in the times that it has been an issue, or that it has come up with clients of ours and even colleagues of ours, it's been extremely rare that the state will even seek that additional support.
Okay.
Does that help?
Yeah, and then I didn't mean to cut you off, but when you were telling me, what the spouse that's living at home, what they're allowed to have. So you gave, the equity, the income, they're allowed to have a car, anything else?
That's really it. It's the 129,000 of assets, right? Checking accounts, savings accounts, IRAs, 401ks, cash value of life insurance. Just so everybody knows, cash value of life insurance counts as an asset. So that counts towards the 17,500. If the individual going to the nursing home has a cash value life insurance policy, if the spouse at home has a cash value life insurance, that cash value counts. They look at it no different than what's in a checking, money that's in a checking account or a savings account.
And IRAs count.
IRAs, yes, yeah. There are some states where IRAs don't count for Medicaid, but Illinois is not one of them, unfortunately.
Could you repeat the dollar amount of the spouse that's in the nursing home can have in income per month again?
Income per month, they can keep $60 of their income.
Oh, they can keep $60. But you said about the part where they can transfer
if they have a spouse. So if they have a spouse.
And that's still that $60, they could give the $60 to their spouse?
No. So here, let me make sure I clarify that. So if I'm in the nursing home and I'm applying for Medicaid, and my wife is living in our, still living outside the nursing home in our house, I get to keep my $60. I get to keep, let's say my income is 2,000 from Social Security. I get to keep $60 of that. I can pay for my Medicare supplement. And then the remainder, I can transfer the remainder to my wife if her income is less than the 3853 that she's allowed to have per month. Then I can only transfer income to her to get her up to that number. I can't push her over it.
Okay, so I get $2,000 a month.
Mhm.
I get to keep 60, say my Medicare supplemental is $200 a month. So that's
Mhm.
260. So now
Right, so
I'm
1740 left.
yeah, so it's 1740. That 1740, if she's say at $1,000, I could transfer that entire
Yes,
1740 to her?
yes, yes.
Okay,
And then you have no financial responsibility to the nursing home on a monthly basis. And Medicaid would simply pick up the entirety of the tab.
okay, perfect. This is very helpful. Thank
Good.
you.
Yeah. Now,
What happens if
I-
you have what happens if you own your house in a land trust?
so
Does
what
that have
happens
any
is,
bearing?
no, it doesn't, it's not going to protect it or anything. What'll happen is, so let's say my wife and I have our house in a land trust, most likely we're the beneficiaries, right? Most likely we have the beneficial interest in the land trust, right? During our lifetime, it's for our benefit. And then, I mean, if we're putting a land trust together, ideally, in most cases, we'd have beneficiaries named, right? That's the whole purpose of it, to make sure that it avoids probate. But if I'm applying for Medicaid, if I'm going into a nursing home on Medicaid, the house would have to come out of the land trust, and it would have to go into my spouse's name only. This is also similar, like if there's couples that we meet with, and they have a joint trust, right? So let's say they had the John and Jane trust, but John's in the nursing home now, going to be applying for Medicaid. We've got to take that house out of the joint trust and put it in the wife's name only. In some of those situations, we might be creating a single trust for that spouse that's not in the nursing home, just so we can continue to keep that house protected from probate and make sure that we've got things set up the right way. So yeah, it's got to be, the house has to be out of the, if I'm the one in the nursing home, I cannot have the house in my name. I can only have $17,500 in my name, so I can't be joint on all these accounts that I might have been joint on with my wife prior, that totaled $200,000. I mean, we've got to be very careful as to how we split things up. And there's different things that we can do in these situations, as far as like making, recommending about, how we can spend money down to get to a point where we can apply for Medicaid. There might be certain situations where we can do some work to help protect some of the assets. There's different strategies in some of these cases. And, in some cases, there's situations where we work with clients that are not in a situation where they need any kind of care. And we're doing some pre-planning to see, okay, what can we do now in case one of you needs, long-term care, 5, 6, 10, 12 years from now or more, is there anything we can do now to set things up so that we can protect some of your assets? And so God forbid one or both of you needs to go into a nursing home at some point and maybe apply for Medicaid. Can we sort of set some assets aside now so that you don't have to sell your house? You don't have to spend down, the money from all these accounts. So, there are, again, I'm not going to say in every single case, but there can definitely be opportunities to do that. Those were some good questions.
Does anybody else have a question? I don't want to monopolize, but I do have questions. Okay.
These are good, Gloria. These are good questions. Like, we're touching on some estate planning topics, elder law topics. People are getting a little taste of everything based on your questions.
Okay, so what is the easiest way to start to retitle bank assets, if you're going to set up a trust?
I don't, maybe you can when you say, so, okay, so to make sure I understand, you're asking, once you have a trust in place, what's the easiest way to retitle
The
like bank
bank
accounts?
assets, yeah.
I mean, honestly, it's really just, every institution is going to be different, but most of your retail banks like Bank of America, Chase, Fifth Third, PNC, etc. For those, almost in every single case, you're going to have to go into the branch, you're going to bring a copy of your trust, and you're going to sit down with with a banker. And I always recommend to my clients that they make an appointment ahead of time. And so the bank, the bank knows what they are coming in to do, and that way, ideally, you're not sitting down with somebody that has never done this before. That's the last thing you want to be doing, is sitting down with a banker that hasn't dealt with somebody with a trust. As common as trusts are, you've got new bankers, you've got bankers that have just never dealt with it before. So I recommend making an appointment with the bank, and then ultimately, though, there should be some guidance from your estate planning attorney. I mean, I can only speak to what we do. And so, I'll sit down with clients after we put their trust in place, and after they sign it, and literally right there, once we're done signing the documents and my assistant is scanning them, we're sitting down and we're going through every single account they have, every single checking, savings, money market, brokerage, CD, IRA, 401k, life insurance policy, etc. And we're giving specific recommendations about what to do with every single account. This account, I want you to update the beneficiaries to this. This account, I want you to retitle it to the trust. This account, you know what? I know how that bank operates. They're not that easy to deal with as far as opening up a trust account. Maybe we want to do it this way. So, I guess I probably should have started with saying, really the first step is that you should really be probably talking to your attorney to make sure you know exactly how things should be titled, number one. And then, really from there, it's going to be, in most cases with like the retail bank accounts, you're going to have to go into the bank. Anybody named as a trustee is going to have to be there, with the trust, and then to either retitle the accounts. And in some cases, you might have to open up a new account and move money over and close the old account. Again, that's very bank dependent. As it relates to the brokerage, the brokerage houses like Wells Fargo or UBS or Morgan Stanley or Merrill Lynch or whatever it might be, those, most people tend to have a financial advisor they're working with, right? Or Edward, if you're working with somebody at Edward Jones, those tend to be the easiest ones. Okay. What's funny is I always tell clients, I'm like, it's like the accounts that my clients have where they've got 3, 4, 500,000, 1.5 million. Those are the accounts that are like the easiest ones to retitle to their trust. It's the accounts, it's like the Chase Bank accounts or the Bank of America accounts or the Fifth Third accounts that have like $5,000 to $20,000 in them that are the most difficult ones to retitle. And then as it relates to real estate, because if you have real estate, it should be in the trust. And I heard you reference a land trust earlier. In most cases, if we're creating a trust, we're getting rid of that land trust. There is no reason to keep that land trust in place. We're putting it in the revocable trust, and we're getting rid of that land trust. We're going to stop paying those land trust fees. It doesn't make any sense. Very rarely would I ever encounter a situation where it makes sense to keep a land trust when somebody has a revocable trust in place. And so typically the attorney, I can only tell you, again, I can only speak to what we do. We will always retitle real estate. Okay. Our clients aren't going to figure that out. We draft a deed and we record it with Cook County or Lake County or McHenry, wherever they live. And we transfer title of the house to the trust. If there's, we got to be conscious that we might have properties in other states, right? We might have that lake house in Wisconsin or Michigan or Florida or whatever, wherever we're fortunate enough to have a second home. Again, at least what we do, we will consult with an attorney in that state and have them help us, right? And prepare a deed and have our, we'll meet with our clients to sign it when they sign all the other documents. And then we'll get that to that attorney, and we'll make sure that that property in Florida or Wisconsin or wherever it is, that property gets retitled to the trust as well. We don't need a separate trust for a property that's in another state. Nobody's necessarily asking that question. I'm just saying it because it does come up often where they're like, oh, do I need a separate trust for that house I have in Wisconsin or wherever it is? And we don't.
I'm sorry, I have a quick question. You said revocable trust. What's the difference between revocable and irrevocable?
In most cases, so there's different types of irrevocable trust. So I can speak to an irrevocable trust that we use. So revocable means that you can make changes to it. Okay. Technically you can revoke it. So you can completely, get rid of it. That's not that common. There's normally, very rare that somebody would actually revoke their trust. It happens, but revocable means that I can make changes to it. Okay, so 5 years from now, if something in my life changes, I want to make changes to the trust, I can do that as long as I have capacity. A revocable trust is also one that I can be in control of, so I can be the trustee and I can continue to manage my assets just like I always did. Nothing changes in my life. I always tell clients with a revocable trust, you deal with everything just like you did before you had a trust in place. You file your taxes the same. There's no tax ID number. And the trust is for my benefit. Again, it just means that I can do whatever I want. Nothing changes. It's just that now the accounts, I say that the biggest change you're going to notice is that the statements you get from Bank of America, rather than saying Matt Margolis and then my address underneath, it's going to say the Matt Margolis Trust dated January 1st, 2025, Matt Margolis trustee, and then my address. So that's a revocable trust. It's going to be the most common type of trust that people have. You talk to anybody that has a trust, I'm going to just say 95% of the time, they'll be a revocable living trust. An irrevocable trust, at least, and again, there's different types, but the type of irrevocable trust that we would use, and in a lot of cases, how an irrevocable trust would work is that you cannot make changes to it, right? So once that trust is drafted, you cannot amend it. So if something changes 5 years from now, oh well. Okay, whatever the trust says, that's what the trust says. And in a lot of cases, you cannot be the trustee. So if I'm creating, well, I cannot be the trustee, right? So if I'm creating an irrevocable trust, I can't be in control of it. So I create this irrevocable trust. I just retitled a $150,000 brokerage account at Wells Fargo to it. I can't have direct access to it, right? My son or my daughter might be the trustee. They're the one that's going to have access to that account. And then lastly, at least again, the irrevocable trust that we use, I'm not going to be a beneficiary of the trust. So during my lifetime, I'm basically giving up my rights to these assets. Okay. Now there's more to it. I can't get into it all because we only got about 7 minutes here. I want to just leave a couple minutes at the end. But I wouldn't be a beneficiary of it. And really the reason for this irrevocable trust for us, and for a lot of people when they use an irrevocable trust, it's to protect assets. You're doing it to protect assets. So this irrevocable trust that I'm kind of referencing, this is the type of trust that we would use when somebody, maybe somebody comes to us and they're like, hey, listen, we don't need care now. We're concerned that we might have long-term care needs, down the road. Is there anything we can do to protect our assets? And this is the type of trust that we would use to protect the assets. Because the one thing I didn't talk about with Medicaid is a 5-year look back. So if I go to apply for Medicaid, they're going to ask for 5 years of all my financial statements, all my bank accounts, right? All my bank statements. And they're basically looking to see that I give any money away over the last 5 years to get myself down to a point where I'm Medicaid eligible. Okay, so if we do this, if we put together this irrevocable trust, this asset protection trust that we call it, and we retitle accounts or we put a house or we put assets into it, now the goal is ideally we're not in a situation where we're needing to apply for Medicaid for over 5 years. And then anything we put in that trust is completely off the table if we ever apply for Medicaid. But again, that's why I can't have control of it. And that's why the trust can't look like it's for my benefit.
Okay, that makes sense. Now, if you have a trust where there's like two of you, like in my friend's case, it was her mom and her dad. The mom died, so now the dad is total beneficiary. When he died, does that make the trust irrevocable as well, now that he's dead?
Yes. Yeah.
Okay.
Mm-hmm.
So, can you, are you still there?
I'm here. I want to save like 3 minutes at the end here, just because I want to bring a couple things up. So, but if you've got a quick question, I can answer it, Gloria.
Yeah. Can you explain the necessity of having a pour over will?
Okay, so I'll try to be as brief as I can here. So basically, every time, in some cases, people will just create wills. Okay, I'm going to try to do this as quick as I can. Sometimes people will just create wills, and a will on its own does not avoid probate. Okay, so if I have a will, but I own a house and I've got a bunch of accounts and there's no beneficiaries on them when I die, especially with my house, even with a will, if assets are in my name only with no beneficiaries, those assets will go through probate when I die, and then my will kick in and the judge will look at it, and all that stuff that goes through probate, the court process, will get distributed according to the terms of my will. Okay, now the goal of a trust for most people is to avoid probate, right? Most people don't have over $4 million. So in most cases, we're not using trust because we want to protect against estate taxes. The vast majority of people are putting a trust together simply to avoid probate. Well, I kind of referenced this a few minutes ago based on your question, Gloria. I can put a trust together for clients, right? We can do a really good job of doing that. But if they don't, and we'll retitle their real estate, right? Like I mentioned, we will retitle their real estate. But if they don't take the advice and the recommendations that we give them, as far as going to the bank to retitle their bank accounts to the trust or retitling those brokerage accounts at Wells Fargo to the trust, and they have those accounts in their name only when they die, right? Or, the husband dies first, the wife dies second, and that brokerage account at Wells Fargo is in her name only. She never retitled it to the trust. There's no beneficiary. And that brokerage account is over $100,000. It's going through probate. Okay, so even though she has a trust, it is going through probate, which is the court process. And in that case, the pour over will kicks in. So in every case we have a trust. In every case where somebody creates a trust, we always create what's called a pour over will. The pour over will is a very simple will. It doesn't talk about who the beneficiaries are. Okay, my pour over will names executors, and the executors of my will would probably match up in most cases with the trustees of my trust. Right? Who's going to manage my estate? Who's going to work with an attorney throughout the probate process? Okay, so it names executors, and then there's a pour over provision. The pour over provision of my will basically just says, hey, judge, if we're reading this, two things happened. Number one, I died. Number two, something slipped through the cracks because I have a trust in place. But if you're reading this, that means that something's going through probate. At the end of this probate process, I want whatever assets are going through probate to pour over into my trust. And then my trust will distribute it according to its terms. Okay, so look at the pour over will as like a safety net. It's necessary. There's no situation where we are going to create a trust and not include a pour over will. They go together. But in every single situation where we're creating a pour over will, we are hoping it never gets used. Okay, because if it's being used, that means something slipped through the cracks and it went through probate. I hope that quick explanation helped.
Yes.
Okay, so we've got just like 2 minutes left here, and I just want to bring something up. We just sent out a quarterly newsletter a couple of weeks ago to our entire database of clients and professionals that we're connected to. And so I'm going to just bring up the same two things I brought up in that newsletter really quick. So, one is we're getting toward the end of the year here. I would just want to make sure everybody, not like there's a ton of people here listening, but for those of you that are here, and I guess it's being recorded, so anybody that listens to this in time, make sure you are, if you're in a situation where you need to be taking required minimum distributions, make sure you are talking to your financial advisor, or whatever the financial institution is, where you have an IRA or a 401k or whatever that retirement account is, and make sure you are taking those required minimum distributions before the end of the year, and make sure that you're reaching out to your financial person at least 2 weeks before the end of the year. Don't be waiting until the last minute. I can tell you right now, I've talked to a lot of financial advisors, and from the time they're contacted to the time it gets done, it can be over a week. So you want to make sure you get this done. You want to make sure you're not going to get any kind of penalty from the IRS for not getting those required minimum distributions done. And also just like this should be really simple, but these things fall through the cracks. Make sure you're looking at your beneficiary designations on life insurance policies and 401ks and IRAs and all of those accounts you have. You would be surprised. People come into our office and we've got situations where I'm working with couples, their kids are teenagers, and they still never named their kids as contingent beneficiaries on their accounts. Now, in most cases, I want to make sure we have a trust in place, and we might name the trust and for various reasons instead of the kids, but that's a long story. For now, just make sure those beneficiary designations are the way they should be, right? If you're married, is your spouse first? Do you have kids, or your kids next, or whoever your beneficiary should be? And make sure you don't just have that primary beneficiary. They have contingent beneficiaries, because that primary beneficiary is not guaranteed to survive you. These things accounts like 401ks and IRAs and life insurance policies, where when you open them up, one of the first questions that's being asked is, who are your beneficiaries? These accounts should never go through probate. You should never be in a situation where at the time we pass away, there's no beneficiary listed or no living beneficiary listed. And we had a case a number, 6-7 years ago. We did not do the planning for the person that died. My disclaimer here, but his wife passed away 10 years prior to him. He had 4 kids. When he died, we found out that there was a life insurance policy that only named his wife as beneficiary and no contingent beneficiaries. We had to go through probate for the life insurance policy. He had a trust. Everything else was in his trust. Okay, this is something where it should never have happened. So please look at those beneficiary designations, make sure they're set up correctly. And, listen, some people get divorced and they forget to remove their spouse as a beneficiary in some of their accounts. So, look into those as well. So that's it. That's my quick, two little tips there for the end of the year.
And Matt, I get your newsletter, so I like your recipes.
Oh, thank you very much. I appreciate that. Very kind of you. All right, that's all I got. I mean, we're at the end of the hour here. I don't know if
Wow.
Amy has anything she wants to wrap
No,
up.
that went by fast. I learned a lot too. I think that was
Yeah.
great. I took a bunch of notes, so I'll get them all situated and email them out to the group.
Oh,
Um,
perfect.
and I put Matt's email address in the chat, but I can connect it in the email I send out as well too.
Thank you so much.
Thank you so much, Matt. This was wonderful. We really
Of course.
appreciate your time and
Thank you to you
information.
for arranging it for us, and thank you, Matt,
Oh.
for participating.
Yeah,
Yeah.
thank you, Matt, very
Getting us the
much.
information. I tried to take notes too, but yours will probably be more organized than mine.
I'll try my best.
Here we go.
Thank
And thanks for the great questions, everybody.
All right. Have a great day. Thank you so much.
Take care, everybody. Have a
Thank
great
you,
day.
Bye.
Amy.
Thanks, Amy.